The trial of Kyle Rittenhouse has concluded, and the jury is now in deliberation. While the jury is deciding whether Mr. Rittenhouse is guilty or not guilty, I want to take the opportunity to cover something we don't normally look at while awaiting a verdict: the jury instructions. Before we begin, let me put some bookends on your expectations for this video. I will not be commenting on my opinion of the events that led to Mr. Rittenhouse's arrest. The situation is highly charged, and I have no intention of engaging in a philosophical discussion of the morals of Mr. Rittenhouse's or the injured/deceased party's conduct. Instead, I thought it would be helpful to understand what the jury is charged with deciding and why. These matters are often incorrectly or incompletely reported. Looking at the actual documents and what they say usually gives us a better understanding of what's really going on, often without the spin put on them by second or third-hand reports. The jury instructions are 36 pages long and could also use some distilling. Of course, the devil is in the details, so if you find this video interesting and want to see the jury instructions for yourself, I've linked them in the description below. With that said, let's get to it. The jury instructions are contained in a legal document of the same name and are a standard part of legal procedure when preparing for a trial by jury. The parties, usually through their attorneys, will submit proposed jury instructions, and through the adversarial process, the judge will determine what version of the jury instructions will be final and submitted to the jury for their deliberations. In the US, the jury is only a finder of fact, meaning the jury looks through the evidence and the testimony, including weighing the credibility of witnesses, and makes a determination on what facts they find to be true. To contrast, it is the judge who makes determinations of how the law applies to those facts. So the jury instructions will explain the law to the jurors, ask them to evaluate the facts, and ask them to apply the law to the facts, and make a determination of guilty or not guilty for each of the counts or charges brought by the prosecution. This is a good time to remind everyone that the jury is meant to weigh only the evidence in the trial. The jurors are not supposed to consider social media posts and bystander video or other outside evidence unless that evidence has been admitted into the record by the judge on a request for admission by the prosecution or the defense. The jurors have likely been previously instructed to refrain from reading news or participating in social media surrounding the case. And the general public probably has not seen every second of the trial with every ounce of their attention, as the jury has been required to. The instructions open by explaining that the jurors must render a verdict based on the jury instructions and not based on any opinion or impression they may have from outside sources or even from the judge's behavior. The jury must, quote, decide the issues of fact solely as they view the evidence. The instructions then discuss the issue of self-defense, explaining that self-defense is an issue in this case. The state must prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if 1. The defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and 2, the defendant believes that the amount of force used or threatened was necessary to prevent or terminate that interference, and 3, the defendant's beliefs were reasonable, quote, to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. The standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense, and not from the viewpoint of the jury now. Quote, you should also consider whether the defendant provoked the attack. A person who provokes an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person to reasonably believe that he is in imminent danger of death or great bodily harm, he may then act lawfully in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. The jury will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, the jury will simply determine whether the state has established the necessary facts to justify a finding of guilty. The instructions then discuss the meaning of intent to kill, that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. The law does not require that the intent exist for any particular length of time before the act is committed. The intent may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Intent must be found from the evidence. Intent is not the same as motive. The state is not required to prove motive in order to convict. Count 1 is a charge of first-degree reckless homicide, accusing defendant of causing the death of Joseph Rosenbaum. A person convicted of first-degree reckless homicide is one who recklessly causes the death of another under circumstances that show utter disregard for human life. Under Wisconsin law, there are 3 elements. All elements must be satisfied beyond a reasonable doubt for a juror to vote for conviction. 1. The defendant caused the death of another. 2. The defendant caused the death by criminally reckless conduct, meaning the conduct created a risk of death or great bodily harm to another, and the risk was unreasonable and substantial, and the defendant was aware that his conduct created this risk. And 3. The circumstances of the defendant's conduct showed utter disregard for human life, with the jury being allowed to evaluate the entirety of defendant's conduct and motivation through all facts and circumstances relating to the conduct. Counts 2 and 3 of the charges accuse the defendant of recklessly endangering safety in the first degree regarding defendant's conduct against Richard McGinnis and another unknown male. This crime is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. The state must prove 3 elements. 1. That the defendant endangered the safety of another human being. 2. That the defendant endangered safety by criminally reckless conduct, using the same definition from count 1. And 3. That the circumstances of the defendant's conduct showed utter disregard for human life. The instructions then explain the rules of self-defense as to Richard McGinnis using the same definition from the earlier instructions. Count 4 is regarding first-degree intentional homicide and includes a fallback to second-degree intentional homicide or even first-degree reckless homicide. The instructions explain the defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty, you must consider second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. Intentional and reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. Both intentional and reckless homicide require that the defendant caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant acted with the intent to kill. First degree reckless homicide requires that the defendant acted recklessly and the defendant's conduct showed utter disregard for human life. The jury is also instructed to consider self-defense for this count. First-degree intentional homicide is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. A defense to first-degree intentional homicide is whether defendant has actual belief that the force used was necessary, requiring the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm. Reasonableness is not an issue in first-degree intentional homicide. The jury is to be concerned only with what the defendant actually believed. If the defendant finds not guilty on first-degree intentional homicide, then they are required to consider second-degree intentional homicide. The difference is in the definition of that third element. Rather than requiring the lack of an actual belief that the use of force was necessary, the second-degree charge requires the state to prove that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The prosecution can make their case by showing any one of three circumstances. One, that a reasonable person in the circumstances of defendant would not have believed that he was preventing or terminating an unlawful interference with his person, or two, that a reasonable person in the circumstances of defendant would not have believed he was in danger of imminent death or great bodily harm, or three, that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. If the jury finds not guilty on second-degree intentional homicide, they are required to consider first-degree reckless homicide. The standard for first-degree reckless homicide is the same as count 1 from earlier, requiring criminally reckless conduct, that the conduct created a risk of death or great bodily harm to another, while also being unreasonable and substantial, and that the defendant was aware of the conduct creating such an unreasonable and substantial risk. The reason the charge appears again is that count 4 is regarding the death of Anthony Huber, where count 1 was regarding the death of Joseph Rosenbaum. Count 5 is the attempted first-degree intentional homicide of Gage Grosskreutz, with fallbacks to second-degree intentional homicide or recklessly endangering safety. This charge is the same as we've seen earlier, but regarding the attempted killing of Mr. Grosskreutz. The attempt is captured by the law through the requirement that the prosecution prove that the defendant did acts which demonstrate unequivocally under all circumstances that he had formed the intent to kill another human being and would have caused the death of the other except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. An extraneous factor is something outside the knowledge of the defendant or outside the defendant's control. If the jury cannot agree on attempted first-degree intentional homicide, they are required to consider the charge of attempted second-degree intentional homicide, and if they cannot agree there, they must consider the crime of first-degree recklessly endangering safety. The jury is also required to determine whether any of the charges were committed while the defendant was using a dangerous weapon. If the jury finds the defendant guilty on any count, they are required to answer this question yes or no. A dangerous weapon means any firearm, whether loaded or unloaded. The last 8 pages of the jury instructions conclude with varying miscellaneous instructions. These instructions are still critically important and are quite interesting to review as they summarize many of the standards that apply to criminal prosecutions. These include the presumption of innocence, that a person is not automatically guilty and must be determined guilty by the jury's evaluation of the evidence, that the state has the burden of proof to prove guilt beyond a reasonable doubt. Reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. It is not a doubt which is based on mere guesswork or speculation, or a doubt which arises merely from sympathy or fear to return a verdict of guilt. It is not a doubt such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. The evidence the jury may consider is only the sworn testimony of witnesses, the admitted exhibits, and any facts to which the lawyers have agreed on or stipulated to, or which the court has directed the jury to find. Anything you may have seen or heard outside the courtroom is not evidence, say the instructions. You are to decide the case solely on the evidence offered and received at trial. Improper questions must be entirely disregarded. These are questions that the court did not allow the witness to answer. Anything suggested by the question should be completely ignored and not considered as evidence. Stricken testimony must also be disregarded. Same with remarks made by the party's attorneys. The jury is allowed to consider the credibility of witnesses. In determining witness credibility, the jury is allowed to consider many factors, including whether the witness has an interest or lack of interest in the results of the trial, the witness conduct, appearance, and demeanor on the stand, the clearness or lack of clearness in the witness's recollections, the opportunity they had for observation of the matters they testified about, the reasonableness, intelligence, bias or prejudice, or motives for falsifying testimony, and all other facts and circumstances which tend to either support or discredit the testimony. The jury must then give weight to the testimony of each witness. The judge explains, there is no magic way for you to evaluate testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The judge closes the instructions to the jury with the following message. Now, members of the jury, the time has come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this most important duty. You will not be swayed by sympathy, prejudice, passion, or political beliefs. You will disregard any opinions that you may have regarding what you believe to be my opinions on the guilt or innocence of the defendant. You will disregard the claims or opinions of any other person or media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him. The founders of our country gave you and you alone the power and the duty to decide this case based solely on the evidence presented in this court. You will fearlessly keep faith with those who have entrusted to you the fair rendition of justice and the protection of our freedom. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright Americans, render just and true verdicts. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The instructions conclude by requiring the jury to determine a separate verdict on each count. The verdict must be unanimous. All 12 jurors must agree in order to arrive at a verdict. The jurors will select one member to preside over the deliberations. If the jurors need to communicate with the court during the deliberations, the presiding juror will send a note through the bailiff. Once the jurors have agreed on their verdict, the presiding juror signs and dates the verdict form, and the judge will return everyone to the courtroom for the reading of the verdict and confirmation that the jury agrees with the verdict as it has been read. If the verdict is not guilty on all counts, then the defendant is acquitted and free to go. If the defendant is found guilty on any charge, then the judge is required to hold further hearings on the appropriate punishment and may require the defendant to be held in custody while awaiting sentencing. I don't have much of a personal opinion on the situation other than to say it's a mess. What we want to see happen in society is for these messes not to occur in the first place by refraining from the conduct that led to it. But when these things happen, the best thing for a healthy society to do is to seek justice, fair justice, in the evaluation of the guilt or innocence of the people involved. While it may seem to be a burden to put a defendant through a trial, we as a civilized society use these procedures, this process that is due to the defendant, a due process, if you will, to maintain a peaceful and fair civilization and avoid the anarchy of vigilante justice. Regardless of the outcome of the Rittenhouse trial, I will accept the jury's verdict. The jury has been asked to evaluate a very difficult situation and sits in the best position to make the call based on the actual evidence and testimony presented by both the prosecution and the defense. I will refrain from armchair determinations of guilt and innocence and leave it to you, to discuss your thoughts in the comments below. Thanks for watching. Special thanks to our top supporters in November: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Join me for our weekly production live stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.